Welcome back, Consumer Law 101 listeners. We are here today on our second Pro Series video entitled Amazing FDCPA Case Examples. As always, I'm your course instructor, attorney Aaron Swift, the CEO and managing partner of Swift Law North. As always, we start with an agenda. We're going to talk about a brief FDCPA litigation timeline. We're going to talk about case examples broken down into classifications between bronze, silver, and gold cases. And then lastly, as always, end with consumer best practices. All right, so an FDCPA litigation timeline. First of all, each case is different, of course. This is not legal advice in any way. This is all educational, so there's no guarantee that anyone has a case, let alone any one specific type of case. But generally speaking, once an FDCPA case is filed, the defendant hires an attorney, and you immediately begin engaging in settlement conversations. Depending on how big the case is, how extravagant the facts are, the timeline and damages, the more valuable a case, the longer it generally takes. There's a stage of a case that's called discovery, where both sides exchange information and documents, and then there are things called depositions, which are opportunities for both sides to testify under oath, not in front of a judge or jury at that point, but nonetheless under oath. And then later steps in the case that can even involve a trial. But again, all of those vary. And smaller timeline estimates can take as little as 3 to 6 months, soup to nuts, just depending again on the type of case, the violation, the whole host of factors. Bigger cases can take years, especially if there are appeals involved. In class cases, class actions take longer. So in the general stages, there's pre-stages when you're you're developing the case, figuring out the facts, waiting for violations to happen, seeing if they happen. Those things take a lot of time, you know. But then once a case is on file, it can go pretty quickly. So again, it just depends on the type of case, the value of the case, but those are the general steps in the timeline. Okay, so we're going to talk about some amazing case examples. At Swift Law North, where we have the litigation wing, we break every case into a bronze, silver, or gold classification. And generally speaking, we do that if we think a case is just general technical statutory violation, and that's up to the $1,000. If we think above $1,000 is going to be obtained, that would be in the form of actual damages. And then the worst types of cases, we're talking punitive damages. And I'll slight caveat there. Remember, the FDCPA itself doesn't have punitive damages, but some states do. And for example, in Florida, the state version of the statute has a punitive damage. So when we talk about gold cases, there's a little bit of caveat there. So anyway, a simple bronze case was an instance where a consumer came to us and they had been sued and they were scared. They didn't know what to do. And worse, they were sued somewhere pretty far away from where they had lived. So to get to the courthouse was going to be a problem. Well, that set off alarm bells for us, alarm bells right away, thinking, well, if it's far away, that's pretty inconvenient, but it may also mean there's a problem here. And lo and behold, we did find out that this debt collector had been filing lawsuits in a venue that was most convenient for it. Now, it wasn't caught on that issue enough, unfortunately, but the consumer that did find it and then came their way to us was able to countersue. And we were able to use that alleged, violation to get rid of this quote alleged debt. So the debt was 100% forgiven. We got that trade line deleted from all the credit reports, and we got finality via settlement agreement, where the consumer did not have to pay any of our fees and costs. So that's a great, amazing result on a pretty standard low volume, value case that can lead to some really great outcomes, especially debt forgiveness and trade line deletion. So then a silver case, we had a third-party debt collector who bought a debt, or so they thought, and they kept collecting even though the consumer could prove that prior to it allegedly being transferred or sold, the consumer had settled with a previous debt collector. The consumer this time had done a great job, kept excellent records, and so we were able to show the consumer came to us and was sued. This is another case when it partly involves some violations related to lawsuits. But in this case, the third-party debt collector, this new one, this junk debt buyer, sued even after being put on notice that they were allegedly trying to collect a debt that was only alleged because it wasn't owed at all. So after that, we were able to defeat the amazing case outcomes for the silver case. We defeated the defensive case pretty easily. The consumer didn't have to pay out of pocket for that. Ultimately, the third party debt collector and its attorneys had to pay those fees. And then when we countersued, we made sure again that this debt that didn't exist was now forever, forever gone. It was deleted from all credit reports, and we were able to put $15,000 in the consumer's pocket. That's after everything else is paid separately, all the fees and costs. All right, so then the gold case. This is a really awful case. There's a third party debt collector involved and also a first party creditor. Um, but it's really sad. This poor widow, her late husband had died. He had taken out some credit cards, and later in life, he had gone, had some problems medically and mentally towards later stages with some dementia, and so had started to spend money in strange patterns. Became kind of a compulsive problem later in life. But all those debts were in just the husband's name, and the widow, she didn't benefit from these transactions, so there was no argument that she owed this debt. So her husband dies, and now the third party debt collector kept trying to come after her for these various debts. And even after we got involved, we kept putting him on notice. He died. Here's the law that says she doesn't owe it. It's very specific. Every time you try to collect, it makes her more sad about her late husband's passing, and it just went on and on and on and on. Very arrogant, very aggressive tactics. Well, ultimately, it led to the tune of $100,000 going to the consumer. Again, that was in her pocket. That's after all the fees and costs had been paid because, again, we take these cases on a contingency fee basis, blended way where we get paid ultimately by the bad guys. So those are three case examples under this law. They all are amazing results, of course, but they're pretty typical. Obviously, as the value goes up, the type of case gets less typical, but that's a pretty typical gold result when we're talking about those cases. They're fewer and far between, but they're very valuable, and they deal with a lot of really terrible facts, like the one I mentioned here. But even down to bronze cases where it's a simple issue, they just sued in the wrong county, or they have a technical violation about communicating in an inconvenient way. Because remember, consumers are allowed to now set what is an inconvenient time and place to get debt collection communication. So what if the consumer says only send me emails on certain days because that's how and when I want to deal with these things. It's just there's so much power. So we want everyone to kind of keep in mind about these case examples and then put them into practice. Understand that you have rights. Again, I stress this all the time. Document everything. Take notes about calls. If you end up in settlement situations, get them in writing, and then keep records of the settlement payments. Um, again, check your debt collection efforts against credit reports. And if you think you're being harassed, anything related to these three case examples or something similar, please reach out. You could be entitled to, significant damages like these examples. That can be debt forgiveness, trade line, deletion, finality, damages in the consumer's pockets, and then the defendants have to pay the fees and costs. So for more information, keep visiting consumerlaw101.com, including the rest of the video series for this pro series. And then again, if you haven't issues that you think have already arisen to the level of litigation, visit us at www.swiftlawnorth.com. Thank you.